Joining us in studio as our expert is Mitchell Frankel. Mr. Frankel is a founding partner of Sussman & Frankel LLP, and we welcome him back to the show. Nice to have you back.
Nice to be back.
All right, let's talk a little bit about premises liability. So many different types of accidents that happen in a building. Let's go through a couple. They can't all be slip and fall. Tell me about some cases that happens in buildings.
In addition to, like you mentioned, slip and fall on steps, trip and fall on steps, you have problems with, could have a problem with an elevator. It could mislevel, it could stop between floors, it could potentially drop. There's a whole host of things.
Now, these accidents that occur in a building, many times they can actually occur in the apartment itself. Not always, let's say, in the common area, but actually in your apartment. If an accident does happen in an apartment, do you still have recourse?
You do. There's obviously a difference. If the incident occurs inside an apartment, the person who is responsible would be the tenant of that apartment or the owner of that particular apartment. That could be a friend, a relative.
Let's say you're in that person's apartment, a friend of yours, and they're not careful with the flooring, and you end up taking a spill. You mean that person can be held responsible?
Depending on the circumstances, that person certainly could be held responsible, and you would be in your rights to bring a lawsuit against them if you were injured as a result of their negligence. However, oftentimes, not everyone who owns an apartment or rents an apartment has homeowners or other kinds of insurance to cover. So you would not necessarily have an insurance company behind a potential lawsuit, meaning you'd be suing someone who has no insurance coverage. So that is not your A1 scenario.
Right, you probably lose a friend too. Okay, now let's get
would.
Let's get into the outside of the apartment, into the building itself.
Right.
Stairways, slip and falls, that type of stuff. What are the general type of defects or the things that end up causing people to have accidents throughout a building?
Well, like you just said, with regard to the common areas, the difference with a common area as opposed to an individual apartment would be the homeowner association, if it's a co-op, the co-op association; if it's a condo, the condo association; if it's a rental, then obviously the owner of the building and perhaps the managing agent would be responsible for keeping the common areas such as a hallway, an elevator, safe, a stairway, safe for the residents of the apartment.
You have a superintendent that generally maintains the buildings. Certainly, throughout the city of New York, your superintendent is the person who's supposed to be keeping the areas clean. Right? Am I correct?
Right. Well, the super is supposed to do more than just keep the areas clean. They're supposed to do various repairs and maintenance work. If let's say there's a problem with the ceiling. Some people have problems with their ceilings where their ceilings actually collapse. There may be a water problem above the ceiling in the pipes or coming from the apartment above. Repairs are supposed to be made. Now, you inform the super either can make minor repairs themselves, or then they can contact their boss, which would be the managing agent, and then contract it out to someone to fix that problem.
Which leads, by the way, to the issue of notice, because many people think that just because they have an accident in a building, the mere fact that they had the accident makes them able to recover from somebody. But that's not always the case, is it? I mean, there's something called notice.
Correct.
What do we mean by that?
Well, when you sue a premises owner or occupier for a problem, they have to have either created or caused or created the condition, meaning their employee or themselves created or caused the condition, or something called, as you pointed out, notice. With the notice, it has to either be actual or constructive, and that means simply they physically and actually knew about the condition before from a letter, from verbally, or the condition has existed long enough where someone with reasonable inspection should have been able to know about it.
Well, let's go outside the building now. Now we're on the sidewalks.
Sure.
Who's responsible for that area?
Well, it depends on the building. If it is a commercial space or it's a large residential building, it's the owner of that building is responsible for maintaining and keeping a safe sidewalk. Now, if it's a small 1, 2, or 3 family home, that would be the responsibility of the city of New York. And when you sue the city of New York, then you have a whole host of other issues.
That's very important for the viewers to understand. Why is it different if the city of New York is considered to be a defendant in a lawsuit?
Sure. Well, if the city is involved, there are other hoops you have to jump through. And those hoops involve what's called a notice of claim. That notice of claim is simply a document where you indicate what your claim is, what happened to you, when it happened, and give specifics. And you file that within 90 days of the incident. If you don't file it within 90 days of the incident, you very well could be precluded from ever bringing that claim. Then, once you do that, then you have to appear for what's called a 50H hearing, and that's giving testimony under oath as to what happened to you and what the result was.
Listen, I don't have too much more time with you, unfortunately, but you got to give us some tips here. You're somebody that's in the building. You think you have an accident. Tell me what you do once you get a client who who has a potential injury in a building. Give us some tips. What do you do?
Sure. Well, someone comes in to me with an incident. I first ask for photos if they have it.
Okay.
So hopefully, if something happens to you, you take pictures of the incident as soon as possible, because that condition can disappear. It can be fixed, and if it's fixed, then there will be no evidence of what caused you to fall. So obviously, you need pictures. You need to round up some witnesses. Don't think they're necessarily going to be around later, because they tend to disappear as well. Get names, contact information of any witnesses of the incident. Also, for this issue of notice, try to get names of people who knew about the condition before it happened to you, and also get their contact information.
Okay, speaking of contact information, let's get yours really quick.
Sure.
Where
Phone
can we
number
find you?
212-688-8895, and or email mdf@sussman-frankel.com, and it's on the screen.
We have it on the screen. All right, well, you're going to come back again, aren't you?
I most certainly will.
All right, well,
Great.
Thanks very much.